doing?
Is the video today about forced positivity and burnout or about law?
Yeah, here we come. Hey, here we come. Hey, here we come. Here we come.
The problem with politics is that it's filled with politicians. The problem with law, it's that there are too many lawyers. And there is a reason why so many politicians were once lawyers in their previous lives. Mwah. If I had a billable hour for every time someone told me that I seemed too nice or too honest to be a lawyer, I would have had one heck of a Christmas bonus last year. Oh, let's go.
All right, let's go, guys. Barney, stop. Okay, the problem is not that I believe this to be true. I personally don't believe it to be true. I don't think you have to be a jerk to be a good lawyer. The problem is that the industry believes it. It's not only a sentiment among lawyers, it's a sentiment among clients. People think that if you're too nice and too honest, you can't be a good lawyer, and that is a problem. It is a problem, however, that is confirmed by the nature of the profession. And if I had a billable hour for every time a client asked me why I was being nice with opposing counsel, I'd have at least enough to buy the GoPro Hero 7. On several occasions, I would go into an examination and my client would ask me why I'm being friendly with opposing counsel. And I would tell them two things. The first is, you're fighting with their client. I'm not fighting with him. The second thing is, judges don't like it when lawyers fight with each other. It has absolutely zero positive impact on the file and can only hurt you. Doesn't mean that lawyers don't fight with each other, it just means that they do it in much more passive-aggressive ways. Okay, now, just to open a parenthesis, when I am speaking about law right now, I am talking primarily about commercial litigation, family law, criminal law, any form of law that is fundamentally adversarial. But I'm primarily talking about litigation, and I appreciate that some of these statements are going to be generalizations both of the practice and of the clients. Although they are generalizations, they are not necessarily wrong, and in fact, they are more often than not accurate. Just not of everybody, just of most. A lot, a substantial portion. A not insignificant portion that allows people to come to generalized conclusions about the practice, the lawyers, and the clients. A lot of times you're going to hear people refer to the practice of law as a chess game. It's like one adversary versus another, and it's like a strategic game of chess. You have to follow up some person's move with another move that's better. Anybody who makes that analogy either does not practice law or does not play chess. The analogy fails for one fundamental reason. In chess, all of the pieces are always on the table. There are no surprises that don't result but from your failure to anticipate a move that you could have otherwise foreseen based on the fact that all of the pieces and all of the moves were on the table for everyone to see in plain sight. Okay. Oh gosh, that's down. Well, I'll keep faces out just so it's... Such a shame to have such a beautiful coffee and have someone destroy it. God! Commercial litigation is less like chess and more like poker. Not poker in the sense that you're bluffing or calling bluffs or like making moves and trying to collect chips. Poker in the sense that everybody's playing with their cards down on the table. Nobody's showing you what they have, and you have to ask like the magical right questions in order for someone to flip up their card and tell you that that's actually what they have. But you can never rely 100% on the fact that your adversary is in fact going to show you their cards when the time has come to show you their cards. Imagine poker is like a guessing game where you have to ask the right question for your opponent to flip over the card that corresponds to the correct answer to that question, but you have to rely on the honesty and transparency of that person to actually flip up the card when you ask the right question. And an illustration as to how difficult that in fact can be sometimes, try asking a lawyer a question and getting a straight answer. Funnier still, try asking a lawyer the same question on 2 different days and you'll notice that you get 2 different answers because there will be something different from one day to the next to allow them to distinguish the answer that they gave previously from the answer they're giving currently. The ability to find the answer that you want, not the answer that is true in any particular context, is the hallmark trait of a quality lawyer. Sad but true. And you know what? It's even worse than playing poker. It's not like you're just playing straight up poker where all the cards are on the table. Litigation, it's like sometimes the lawyers are keeping cards up their sleeves, or they have 5 aces in the deck, or they have a card under the table. You know, in law, certain jurisdictions, there's something called full disclosure. When you know that you're going to get involved in litigation, you have to willingly disclose all potentially relevant documentation to the opposing party. In criminal cases, the prosecution has to disclose all evidence relating to the alleged crime to the accused. full disclosure. Other jurisdictions, there's what you call discoveries, interrogations, examinations. You sit down with a witness, you ask them questions, you ask for communication of documents. And ordinarily, if you're playing fair poker, you expect that there would be voluntary, willing, and cooperative communication of all requested documents. The reality is that even in the ordinary course of practice of law, and everybody knows this, you don't get that cooperation. A party is not very eager to communicate documentation that they know will sink their case. Then the trick becomes having a lawyer who is smart enough, who is sly enough to be able to skirt communication of documentation that they know will be prejudicial while respecting ethical and legal standards. And let me give you a concrete and real example of how difficult it can be to actually obtain information even in the context of a legal requirement to disclose. Let's say, for example, you ask for an email. That email has an attachment which is highly damaging to the case of the person who would have to communicate the email. What might a lawyer do? Well, a lawyer would say, okay, you asked for the email, but you didn't ask for the attachment to the email. And you may get the email and not notice that there was an attachment to it, and the other party may have gotten away with not disclosing something that they were legally required to disclose because of a phrasing of a question. Now let's just say that you say, okay, I want communication of all emails and attachments. And let's just say that in the thread of that email, there is something damaging to the case of the person who would be compelled to produce it. What might a lawyer do? Well, a lawyer might say, you asked for the email and the attachments, but you didn't ask for all the emails in the thread, so that they would then either truncate or communicate only the email and not necessarily all the back and forth that followed in the thread. So then let's just say you formulated properly yet again. We would like all emails, attachments, responses, any correspondence whatsoever that was in the context of that email thread. I mean, this is what lawyers have to deal with on a daily basis. You're not playing chess because the pieces are not on the table. You're not even playing poker because the cards are not all on the table. You're not even playing Crazy 8 where if you ask for the card, they have to give it to you. You say, do you have a 7? And they may have a 7, but you didn't phrase the question saying, do you have the 7 of diamonds? Okay, where are we going with this? You mind if I finish the vlog while we go get your lunchbox?
Yeah.
You do mind? You don't mind?
I mean, don't.
Okay. Good. Okay, where were we? I'm too nice and too honest to be a lawyer. What do you think?
I don't know.
Good answer, honest. I am not too nice to be a lawyer. I have the ability to turn it on and off when needed, and it's something that lawyers and opposing parties don't necessarily seem to understand or appreciate. Like, we'll have a heated cross-examination, and when the examination is over, and I'm back to being me, except the other party and their lawyer don't really have that on and off switch, and they don't appreciate that on and off switch, and they stay mad at me for a while, if not forever. And I'm not too honest to be a lawyer either. As far as I'm concerned, honesty is required everywhere at all times. I live with this perhaps irrational fear that if I lie, I'm going to get caught. It's going to come back to haunt me. I take for granted that people are recording conversations just because you never know when they're not, and you would be surprised how often people actually do record conversations. I never take the chance of lying, but the reality is, in litigation, you can't trust anybody. You can't trust opposing counsel. You can't trust the opposing party. You really can't even trust your client because your own client, despite all of your best advice, can be tempted to give in to temptation. They can be tempted to destroy a document that they know is going to hurt them. There's a saying in the industry that lawyers end up with clients that reflect their values, and clients end up with lawyers that reflect their values. You want to walk? Am I out of focus? I'm out of focus. Hold on. Okay, hold on. Stay. It's just staggering me. It's just staggering me. Okay, that's good. The other thing that I never got used to and that only got worse over time, you know that whenever you are talking to, writing to, or corresponding with opposing counsel, they're not trying to arrive at the truth. They're trying to wait for you to say or do something that they're going to hold against you, either in a letter to a judge or in a court proceeding. People are under the impression that the pursuit of law is the pursuit of the truth. It's not. It's the pursuit of your client's position. And whenever you are having a discourse with opposing counsel, just know that they are waiting for you to say something that they can confirm to you in a letter afterwards that they are going to put in front of a judge. That's the nature of the beast. Every time I hit send on an email, my heart would start beating with a little bit of anxiety because I'm wondering, what am I putting in this email that's going to come back to haunt me? Every time I had a phone conversation with a lawyer, you knew darn well it was going to be followed up with an email, a self-serving email, as discussed, when, in fact, what is in that letter was never as discussed. Are we going to take the elevator or the escalator?
Escalator.
Okay, escalator, around the side. Here. Okay, we're done. Gotta go get a lunchbox now. Yeah, and by the way, not to be dramatic, the practice of law is constant stress. It's constant looking over your shoulder. It's constant wondering if you just made a mistake in a file that's going to come back to haunt you. I don't see the lunchboxes. It's constant waking up in the middle of the night wondering if you've forgotten to do something in a file.
I saw them, but they're not alive.
Okay, so let's go to the dollar store. All right. It's raining a little bit outside. So this is the reality of commercial litigation. It's the reality and the self-fulfilling prophecy. Clients don't want a nice lawyer. Clients see a nice lawyer as a sign of weakness. Opposing counsel sees a nice lawyer as a potential target for exploitation. Overgeneralization, but clients want a vicious, cutthroat, aggressive attorney that's going to hurt the other party. By the time that people get to the litigation stage, they are hurt, they have been hurt, and they want to hurt as a result. You know, clients want the lawyer who's going to serve the proceedings on a Friday afternoon just to ruin the other party's weekend, and it's the cheapest, oldest tactic used by all lawyers. I call it the Friday afternoon special. When you're going to serve someone, get them at dinner on a Friday night to really mess with their minds and to really mess with their weekends. Being nice, being honest, being upfront, these are not seen as assets, these are seen as liabilities. Opposing counsel will look to exploit this. It's an industry where compromise is seen as weakness. It's an industry where admitting you made a mistake, it's no coincidence why so many politicians are former lawyers, and it's no coincidence why the very same problems we see in the practice of law, we see permeating politics. There's no room for compromise because compromise is weakness. There's no room for being nice and understanding because that is seen as a sign of weakness. There's certainly no room to admit you made a mistake because that will be held against you throughout the entire file. It will be exploited to the benefit of the other party. It's depressing. It's depressing, but it is the reality. Occasionally, you will have clients that understand and appreciate that being nice, honest, trustworthy, transparent, these are assets in the long run, but the problem is people's vision and their scope is not on the long run. Their time frame of relevant behavior is very short term. They want someone who's going to pound the other party into submission now and right away. It's fundamentally adversarial. It is kill or be killed. There's no room for compromise, and you know which lawyers are going to play fair and play honest and play looking for an actual solution and not just the billable hour. One of the most traumatizing anecdotes that I can remember from the practice of law was not a mentor of mine who was opposing counsel. We were talking, and I don't know how it came up, but the comment came up of, if you're going to settle a file, don't settle it too quickly. And it always stuck with me as to what that represented and how reflective of the industry it was. It's a sad state of affairs. Lawyers have a reputation, they've earned it in part, and clients expect it of them in part. So it is lawyers behave in a way that creates an industry standard where any client coming into the industry expects that, and they see any variance in that standard of behavior as a sign of weakness. That's all. Beautiful sunset behind me. Do we do a time lapse and let the clouds roll out? I say yes. Peace out. Incidentally, I forgot to mention it. Like, share, subscribe, hit the notification button so that you know when I post a new video. Tell me if there's anything you want me to cover, talk about, discuss, or do. And, if it's within the realm of the reasonable and the legal, I take recommendations. So, peace out.